unconditional support and access to residence on personal grounds. Firstly, Greta Secretariat, as well as our member La Strada International, the European NGO platform against human trafficking, and LAFO IBF in Austria. PCUM is a network of over 160 organizations across 32 countries that are working towards social justice and human rights for undocumented migrants. And we see that many of the people who are facing labor rights abuses on a daily basis, almost systematically, have a precarious or irregular resident status. Our networks see that one of the primary barriers to reporting such abuses to the authorities and seeking remedy and redress is the risk that they have to leave the country as a result of interacting with law enforcement. Either we see that people are not informed of their rights as trafficked or exploited persons, or otherwise as victims of crime and required to return or are deported before even entering into any kind of system of support. Even those who do enter a system of support may not be found to be victims of trafficking, and then they're known to authorities and at risk of immigration enforcement. And then even if they are recognized as victims, a residence permit is usually contingent on the criminal proceedings and the needs of law enforcement. So often the permit is very temporary, it's linked to the duration of the proceedings, and they will have to leave at some point. This is contrary to the international and European standards. It means that very few trafficked people are provided with long-term protection and stability and a resident status. It doesn't recognize the investments that people have made, their migration projects, their desire to have a better life for themselves and their families. And quite the contrary, trafficked and exploited people may experience this requirement to leave the country as a form of repeat victimization or even violence, institutional violence and punishment. So with those initial remarks, I just want to underline that for PCUM, it's crucial that there are ways for trafficked people and other workers to access support, stability and remedy without necessarily engaging with law enforcement and regardless of their resident status. Alongside non-discriminatory services, safe reporting and effective complaints mechanisms, we see that secure and long-term residence permits are essential measures, and those permits being on the basis of personal situation and needs and rights. So we're very excited to hear from a very distinguished panel to speak about this topic for the rest of the morning. We're going to hear first from Petya Nosterova, the Executive Secretary of the Council of Europe Convention on Action Against Trafficking in Human Beings. She will give us an overview of the state of play on unconditional assistance and residence permits on personal grounds across the Council of Europe region. Then we will go to Marija Anđelković, the director of the Serbian NGO Astra, Anti-Trafficking Action. She will also provide a regional perspective because she's going to share with us the main findings of the REST project, which did an in-depth analysis from 2019 to 2021 on access to long-term protection and residence for trafficked people. And it also identified some promising practices. Marija will also then reflect on the policy in Serbia and give us some insights on the situation in Serbia. Then we're going to move to Denmark and hear from Mercy Obade, and Michelle Mildwater, who from Hope Now. Mercy is a cultural social worker at Hope Now and Michelle Mildwater, the director. And Mercy is also a member of the OSCE International Survivors of Trafficking Advisory Council. They're going to provide an analysis of the situation in Denmark. And then we'll have time for a discussion and your questions. So without further ado, Petya, please, what are the international standards on unconditional assistance and access to residence? And how are they implemented in practice across the region?
Morning, everyone. It is a real pleasure to be joining you this morning from Vienna, where I'm attending the 22nd Alliance Conference organized by the OSCE, the topic of which is protection, upholding victims' rights and strengthening assistance. And we thought that it is particularly fitting within the theme of this year's Alliance Conference to organize this side event on unconditional support and access to residents on personal grounds. And we are co-organizing this, the Council of Europe Anti-Trafficking Division, together with Accessdepends International, which, as most of you know, is a network of anti-trafficking NGOs across Europe.
Hi.
And PICUM,
Good.
International Cooperation for Undocumented Migrants. I'm actually sitting today, this morning, in the office of LeFeu IBF, which is one of the member organizations of Accessdepends International. So they're very kindly hosting me this morning. Now, so we're joining forces for this side event. The strong legal standards of the Council of Europe, as provided for in the Council of Europe Anti-Trafficking Convention, and the hands-on, practical, everyday experience of anti-trafficking NGOs, as I said, joined together through the Accessdepends International network. The aim of this side event is to analyze the interconnection between assistance to victims of trafficking and residence permits, which is really crucial for the topic of this year's Alliance Conference. The provision of assistance to trafficked persons, regardless of their readiness or willingness or ability to cooperate in the criminal justice process, is the cornerstone of the human rights-based approach to action against human trafficking. And in many ways, it can be seen as a litmus test for the commitment of states to uphold and follow this approach. The Council of Europe Convention on Action Against Human Trafficking has been called by some the Magna Carta of the rights of trafficked persons. It has a provision, Article 12, paragraph 6, which requires state parties to adopt legislative and other measures to ensure that assistance to victims of trafficking is not made conditional on their willingness to act as witnesses. At the same time, there is another provision, Article 14 of the Convention, according to which state parties can choose between granting a renewable residence permit to victims of trafficking on the basis of their personal situation or for the purpose of their cooperation with the competent authorities in the investigation or criminal proceedings. And parties have also the option of issuing permits in both situations. The granting of a residence permit, as made clear by the Convention, is without prejudice to the right to seek and enjoy asylum. The Convention does not set a specified length of the residence permit, but it has to be renewable, and it must be compatible with the Convention's purposes. Granting residence permits to trafficked persons is meant to address the victim's needs and the requirements of combating human trafficking. It is a very important measure since resident status provides victims with a foundation for safety and stability and enables their access to justice, including for the purpose of claiming compensation. So therefore, we consider that trafficking victims' access to residence permits and international protection is an essential part of their access to remedies. So these are two very important provisions of the Council of Europe Anti-Trafficking Convention, which are clearly interlinked. Greta, which is the Council of Europe group of experts on action against trafficking human beings, has noted through its monitoring work that difficulties arise when a country chooses to make the residence permit conditional on the victim's cooperation. And in practice, this undermines the unconditional nature of assistance to victims. Let me give you an example. During its second evaluation visit to Austria, and I've chosen this example because I happen to be in Vienna right now, Greta noted in its report on Austria the provisions which are in Austrian law, according to which victims of human trafficking can get a special protection residence permit, either at the initiative of the competent authority or upon application by the victim. And this is provided that the residence permit is considered necessary for the criminal prosecution of the offender or for enabling the victim to make civil claims in connection with the crimes committed. So while the law does not specify that residence permits are issued for the purpose of cooperation, a pending criminal or civil procedure is a precondition for issuing a residence permit. The authority which issues these permits is the Federal Office for Immigration and Asylum. And at the time of Greta's second visit, there were very long delays in the issuing of these permits. Some victims that Greta met during that visit, that was back in 2014, had waited for almost a year to get a residence permit. So this was clearly very problematic, and NGO representatives that Greta met indicated that victims were left in an uncertain position for extended periods with little or no information concerning the status of their application. So this was a particularly difficult period, which over the time I understand has been resolved. I'll come back to this. Another issue was that very few residence permits were being issued. For example, in 2013, only 6 residence permits were granted to victims of trafficking, for 3 women and 3 men, and 6 permits were extended. So Greta, in its second report on Austria, noted that the legal provision for granting a residence permit to victims of trafficking in Austria, which links the permit to criminal or civil proceedings, in practice undermines the unconditional nature of assistance to victims. Unfortunately, Austria is not unique in this respect. In 2020, Greta took stock of the second round of evaluation of the Council of Europe Anti-Trafficking Convention. And as a result of this stock taking, in its 9th general report, Greta published some statistics. Out of 42 countries, which back then had been evaluated for the second time by Greta, 22 had legislation which envisaged the issuing of a residence permit on both grounds, for the purpose of cooperation and or for the purpose of for the personal situation of a victim. However, 14 state parties out of these 42 granted residence permits to victims exclusively for the purpose of their cooperation in the investigation and proceedings. And 2 other countries had legislation which provide for the issuing of residence permits on humanitarian grounds. So this proportion of 14 out of 42 is clearly important. This has made Greta stress that there are situations in which victims might be afraid to cooperate in the investigation because of the threats from the traffickers, and therefore granting a residence permit on account of the personal situation of the victim takes into account a range of situations, such as the victim's safety, state of health, family situation. And this approach tallies with the human rights-based approach to combating human trafficking. And Greta has invited the state parties concerned to consider granting temporary residence permits to victims of trafficking on the basis of their personal situation, in addition to the existing provision for residence permits linked to their cooperation in the investigation and criminal proceedings. In this context, I would like to stress the importance of the project REST. REST stands for Residency Status, Strengthening the Protection of Trafficked Persons, which was developed by LEFU-IBF and implemented with NGO partners in France, the Republic of Moldova, the Netherlands, Serbia, and Spain. You will hear more about this project from Maria just after me. The project REST was co-funded by the Council of Europe, and it was aimed at supporting trafficked persons in effectively accessing and enjoying their right to residence permit and, in appropriate cases, to international protection. The final report of the REST project was published in February last year, just over a year ago, and it is being referenced by Greta in its country reports because it provides a real in-depth legal analysis and case studies analysis with the identification of gaps, barriers, as well as promising practices. So I'm coming back to Austria now because we have seen some evolution from between the second and the third report. The third report on Austria, which Greta published in 2020, noted that the process of granting residence permits to victims of trafficking had been accelerated and the situation had improved compared to what was observed in 2014. Nevertheless, the type of residence permits which continue to be issued to victims of trafficking creates difficulties on several counts. In the first place, the residence permit has to be accompanied by a separate work permit. In the second place, the fact that victims of trafficking are issued a residence permit under of this they receive. And this makes more suspicious and uncertain about employing them because the grounds of the permit are not or were not well understood. Additionally, the residence permit is issued for up to 1 year and can be renewed if the victim has found a job in the meantime, which in practice proves to be difficult. Victims who do not speak German are under pressure to find a job without having time to follow language classes, which would, of course, increase their chances of finding employment. Additionally, the permit is not valid long enough to make employers interested in employing a victim of trafficking. And finally, due to the bureaucratic requirements linked to the number of documents necessary for verifying the identity of victims, the issuing of residence permits is delayed, leaving victims in a situation of uncertainty. More recently, Greta published his third report ago, where similar problems were discussed, analyzed. In France, trafficking is known as CESEDA, it is the abbreviation of the law, and it provides that the foreign national who made a complaint against the person accused of committing trafficking or pimping related offenses, or who gave evidence in criminal proceedings in relation to these offenses, can receive a temporary residence permit lasting for 1 year, which can be automatically renewable for the duration of the proceedings. There is an additional condition that the person has to have severed all ties with the alleged perpetrators, which imposes an additional barrier, if you want, a hurdle. And there's another piece of legislation for controlled immigration, effective right to asylum and successful integration, which contains a provision enabling victims of trafficking to benefit from another route for residence. After 5 years, they can obtain a 10-year residence permit, provided that they have sufficient funds in relation to the minimum wage and health insurance, and they fulfill the integration conditions. So these are the two legal bases for residence permits in France, but in practice, the statistics that are available from the Ministry of the Interior indicate that very few residence permits are issued to victims of trafficking. And according to NGOs who assist victims of trafficking, in 2019, only 26% victims assisted by the NGOs received a temporary residence permit.
Sorry to interrupt you. If you could.
Yeah, I'm rounding up. Because my 10 minutes are expiring. This was just about finishing. Another provision which I wanted to discuss is access to international protection. And here I want to mention that Greta published a year ago a guidance note on the entitlement of victims of trafficking and persons at risk of being trafficked to international protection, which analyzes the application of the principle of international protection in the context of human trafficking. And it builds on earlier UNHCR guidance, and it is also relevant in this context. Thank you for your attention.
Thank you, Betty. I'm sorry to rush you there at the end. Really, really useful overview of some examples showing not only that we have to look at whether the permits are being provided, but also the procedure to issue the permits, and then the quality, the type of permit that's actually being issued in terms of its length, the access to the labour market, and this kind of thing. And underlining, of course, that it's in the convention and it's really recommended by Greta to have these residence permits on personal grounds. I'll then move over to Maria. Petya already introduced a little bit the REST project. What else would you like to add? What did the REST project find? And then could you share with us also what's the situation in Serbia, please? You have the floor.
Good morning, everyone, also from Vienna and 22nd Alliance meeting. Thank you for organizing this event. This is a really important topic for us in this moment. Petya already mentioned a bit about the REST project. I will just say that all the findings I will present today are coming actually from the REST project, which is short from Residency Status Strengthening the Protection of Trafficked Persons. And this is the project implemented by the group of NGOs, namely LEFO from Austria, CCM from France, Project Esperanza from Spain, Comencia from Netherlands, International Central Estrada from Moldova, and Astra from Serbia. And it is based on our experience and practice in support trafficked persons in the process of safety, stability, and social inclusion. Within the first phase of the project, we defined the recommendations within the Guide of Promising Practices. And in the second phase, we look deeper in granting the residence permit and challenges victims are facing in practice. And we developed policy brief called Challenges on Granting the Residence Permit to Foreign Migrants, Victims of Trafficking. Just to give you a short overview of the situation in Serbia in this moment, so you can get the bigger picture. We are still country of origin, transit, and destination for trafficked persons. Dominant type of exploitation is sexual exploitation of women and girls in more than 80% of the cases. But also we have cases of labor exploitation, forced begging, forced committing criminal acts. Residence permit topic has become more important for us since in the last several years we detected influx of migrant workers working on the state infrastructure projects. Several cases ended up in public due to the serious violations of workers' rights, bad working and living conditions, and labor exploitation at infrastructure government construction sites like building the highway in Serbia, factories, Belgrade waterfront, and so on. There are workers from Turkey, India, China, and one of the latest cases, probably you heard about it, went in public. It's about 40 workers from Vietnam building the tire factory for Chinese company in Linglong. The last case resulted by the EU Parliament resolution, reaction from the UN Special Rapporteurs, and recommendation from the UN Economic and Social Council, but unfortunately neither with the reaction of the Serbian government, not at least proper reaction from the relevant anti-trafficking institutions in Serbia. Apart from these very visible cases, we also have a great dark number of invisible victims in domestic servitude and workers exploited in agriculture and caregiver professions. Mostly we are talking about women here. As it was emphasized yesterday during the first panel, a proper identification is based for any further assistance and support to potential victims of trafficking. One of the good practices that we identify within the REST project is the practice that we have in Serbia in law and in theory. And that is identification of victims is done in the social system by the institution called Center for Victims of Trafficking. And this process is parallel and different from the process of identification of the criminal act of trafficking in human beings, and also collecting the evidence, which is done by the police and prosecution. According to this principle, what I explained, the principle of unconditional support to victims of trafficking that Petio also mentioned is fulfilled, at least in theory. What does it mean in practice? It means that victims is granted 3 months recovery period, residence permit, security and protection, shelter, psychological and material finance support, access to emergency health support, access to education for children, and access to free legal aid in its own language. That it means in law and theory. According to the study we conducted within the REST project, in Serbia, we have 5 grounds for granting the residence permit. First one is temporary residence permit for foreigner who is presumed victim of trafficking, according to the Law on Foreigners, Article 62. The second is temporary stay for identified victim of trafficking for 1 year, Article 63 of Law on Foreigners. The third is temporary residence for humanitarian reasons, Article 61. Then we have also persons who have been issued a registration certificate intending to seek asylum seekers. And the last one, persons granted asylum. I will now focus just on the first two to explain the position of potential and victims, presumed and victims of identified victims of trafficking. Focusing on the first ground, according to the Article 62 on Law on Foreigners, Center for Victims of Trafficking is the only entitled institution to submit the request for temporary residence permit to the police department for the foreigners for the potential victims of trafficking, in the name of potential victim of trafficking. The police can grant 90 days of temporary residence permit, which is actually a recovery period in which center can identify victims and during which time victim cannot be deported from Serbia and can think whether she will or will not cooperate with the authorities. After identifying the victim of trafficking, officially trafficked persons can keep all the rights that I mentioned, plus can get 1 extra year of the residence permit, right to work, and professional upgrade and medical assistance. So everything that I said above might sound pretty nice until we look into the practice, and I will show you this in two concrete cases. First case is the case of a young woman from Asia who legally entered Serbia with D visa, and she was exploited in domestic servitude within one famous family in Serbia. And after managed to escape, she asked for help from Center for Victims of Trafficking. Center didn't follow the procedure of Article 62 and didn't apply for temporary residence permit for potential victim of trafficking. So she got into the illegal status, losing all rights prescribed above in the law and facing potential deportation. She also has no decision on her status and no possibility to appeal. This is direct violation of the Article 62, but also of some other articles in Constitution of Serbia. The second case is the case I would like to refer is the case of the elderly man from Western Balkans country who survived extreme labor exploitation in agriculture. But this time he was identified as a victim by a center, and later he testified before the court, and then he was repatriated to his home country in terrible health condition. But he was never granted residence permit in Serbia because the procedure explained above in the law was not followed. And actually the center never initiated the residence, getting his residence permit within the Ministry of Interior. This is the direct violation then of Article 63, flow of foreigners, and opposite from the woman from Asia, this case, who has no paper about the center decision. This man got a paper about center's decision called findings and opinion and not decision, which means that it could not be challenged on the second instance, which is against administrative law and constitution of Serbia. So in many cases like this, Serbian police tolerate illegal status of the victims, but this is really voluntarily an ad hoc attitude of the institutions, and it is unnecessary since we have possibilities in the law, and also it could make feeling of uncertainty for the victim's position. To conclude, the consequences of not granting the residence to the potential victims of trafficking directly influence all victims of trafficking, but especially it is visible in the cases of foreign citizens and migrant workers, because they directly lose right to the shelter, health support, free legal aid, and before all, they will face deportation, which will then be obstacle for all other assistance. Thank you for your attention.
Thank you, Maria. So a lot of food for thought there in terms of potentially good law and theory, but not yet in practice. We'll move now to hear about the situation in Denmark. Michelle, Mercy, can trafficked people access residency in Denmark as in Serbia? How does the situation compare or differ? And how do you see these impact really the daily lives and options for trafficked and exploited people in reality?
Well, our experience is very much from the groundwork that we do, outreach work, meeting and interviewing many trafficked people. Out of the people that we meet, there's only a small group that we end up being able to identify officially as trafficked. In Denmark, the procedure is that it is the police mainly who are doing raids, and that they, over the last 4 or 5 years, have almost exclusively, when they arrest people, have contacted the Center Against Human Trafficking. However, up until this year, the NGOs were included in the procedure for actually identifying people as trafficked. Hope Now's work in that area was specifically to our building of trust with specifically, but not only, the African diaspora. This resulted in us being able to contact people who were potentially trafficked, interview them, and then write a so-called 1A document, which reflects the description of a trafficked person according to the Palermo Protocol. In other words, with vulnerability and recruitment ending up in exploitation. Our big challenge has been that there have been a series of what we notice to be administrative procedures which have resulted in people who are trafficked, often but not always, in fact, ending up being criminalized by the state. This last year, for example, and right at the moment, we are working with 5 people. We worked with 5 people, all who actually were officially identified as trafficked and who have now remained in prison for longer or shorter periods, despite being identified as trafficked. This is something new because, for example, 10 years ago, when we went into prisons and found people who had not dared to, in the first part of the process, admit that they were trafficked, when we've gone in with the background that we have and the fact that sometimes we've already met people through outreach work, we were able to gain the trust with them and for them to tell a story about human trafficking. This would, as a general rule, always, in fact, allow them then to be released. They would then be released and offered semi-permanent residency, but this would only be within the confines of, at first, if they were defined as trafficked, they would be told, well, now you can go to a shelter, but we will give you a 30-day residency, but only on the grounds that you sign a document that says that you agree to return to your country of origin with a so-called voluntary return. So residency in Denmark is based and has been based for many years on an immediate agreement by the victim of trafficking to return to country of residence. And these documents have to be re-signed every 30 days. Otherwise, the person cannot stay. This is confused and also made a lot of pressure on, we feel, the people who are victims of trafficking, because in fact, this idea of a reflection period, it does not actually exist, because the moment they are defined as trafficked, then they have to sign really and be prepared to go home. Many of this group, therefore, have had a tendency to move away from that way of being involved with the system and seeking asylum. Our experience is that people who are victims of trafficking who seek asylum have in fact never ever received protection through that method. For example, all West African women from Nigeria, you will see at the end of the decision, the final decision, which will occur when they have been through an appeal procedure, the actual last sentences will be that this person can seek help and protection anywhere else in the country of origin, particularly Nigeria. They can go somewhere else. They can seek assistance from NAPTIP. And this is where it stands as an absolute general rule. In fact, I can prophesy to a person exactly what will be at the end of such a document with the refusal. Our deepest concern at the moment is that despite when we last year in 2021 managed to, through our outreach visits into prison, find, for example, a number of people who we found to be trafficked and who ended up actually being officially identified as trafficked. We now find that there is a bias against men who have been defined at a later point as being trafficked. And these men, if they have, in connection with having been trafficked, committed fraud at any point, basically, I would say, the keys are thrown away. These people, even though they are defined as trafficked and they are supposed to receive a reflection period with psychological help and assistance, they now are no longer released from prison. We have a system where, unfortunately, most of the lawyers are only paid for a certain amount for what they're supposed to be doing. Once we are involved in a trafficking case, this takes a lot more time and energy from a lawyer, and the lawyer also has to be trained in, for example, bringing up the non-punishment clause and making clear a clear connection between the fact that the person was trafficked and the person committed, for example, fraud. In a number of the cases last year, there has been an extremely clear connection, but this has never been brought up in court. A number of these men have been in prison, not just for a month or a couple of months. I've just worked out recently with one of our volunteers doing data that between, I think, the 4 men that we worked with last year, they have been in prison for a period of over 4 years. The first part of the procedure was when they were not actually defined as trafficked, and this was due to the fact that nobody really was able to interview them or gain trust with them. Even after we identified them and had them officially identified as trafficked, our last client was officially identified as trafficked in October 2021 and remained in prison for over 4.5 months after he was identified as trafficked. These people are then paradoxically, or in a strange way, which they find extremely confusing, they are offered from prison a voluntary return. A voluntary return is a strange word for, in fact, a deportation. The only thing that we will say that is something we're happy about is that the government has still decided to actually give assistance to these men, for example, that we've been working with, so they can receive some of the benefits of a voluntary return. But I think that it is an incorrect description to describe this as a voluntary return when it's actually a deportation with some assistance. The assistance is okay, but it is really against all the basic principles of what we're working with. As regarding residency, residency is not granted to people in Denmark. All of the new laws regarding immigration that Inger Støjberg, the minister, brought in 2016, which she celebrated the 50th Amendment to tighten immigration controls with a cake with 50 candles on. This has really resulted in it being almost impossible in any way for people to get, for example, to seek work and to seek residency. In order to seek work, you have to have a contract. Basically, I'm being a bit rude here, but really a brain surgeon. There is a list of people who are unwanted, and they include carpenters, plumbers, anybody who has ordinary skilled work and earns under around 43,000 krona a month. Possibility for residence is about 0 for trafficked people and also for nearly all other migrants in Denmark. And if anything, it has become tighter. What is interesting is that this unwillingness to actually provide any kind of residence or work permits is now going to change dynamically and completely with the influx now of Ukraine people coming in. So it's going to be very interesting to see how this is going to be tackled now, but we remain in a situation where trafficked people certainly have no possibilities for full-time residency of any kind or work. I'll pass you on to Mercy now, who has had experience herself within the Danish system.
Yeah, good morning, everybody. And I just want to say thank you so much for Lastrada International for giving me this chance to talk about the residency in Denmark. As a cultural mediator, I've really worked with mostly Africans, and I find it also difficult for them to get permission to stay in Denmark, to be given residence here in Denmark, because for you to get a residence here as a man or a woman, it's forced you to get married or to have a child with a Danish person. And you can imagine somebody who is traumatized and who is a victim of human trafficking, bringing a child on this world or getting married to a person so that he can have residence to stay in the country. That is another trauma all through, because even if you get married and you have a child and you still can't take care of yourself and you're still traumatized, that means that you can't even take care of your child, and the child can be taken away from you with the government. And also men, it's also hard for men also, even if they get if they don't have residence here in Denmark and they have a child with a Danish woman, it's hard for them to have access for the residency here in Denmark. So you find out that the residence in Denmark is not something which works, because you are just doing it for the purpose of surviving. So it's just a double trauma for the victims here in Denmark, for the especially for the foreigners, which we are working with. So you find out that even we are as we do outreach and going out in the prisons and finding our victims in the prison, some of the victims, they can't even speak good English, so they can't even communicate because the trauma they're in. So you find out that even if I go in, me as a East African person, I've learned to speak Pidgin Nigerian English so that I can always communicate with the victims. So even if I go to the prison, you find out that maybe somebody's there and she will stay in the prison because they say that she can't communicate. They don't know what to do, but it's not about the communication. It's about the trauma, and just find the right person who can really express her feeling. But I find it's always easy for me to express their feelings because I've been in this situation before. So when I got there, for example, we have a woman who was in the prison, and she can't speak good English. She couldn't communicate with the police, and her word was, "I don't understand anything." So they thought that she was mentally disturbed. She was not okay. So when we came in as Hope Now, I insisted, no, I want to see this lady. So when we went there, and then she saw me, because it's somebody I've met on the street of Copenhagen. And she said, then you can, in Pidgin English means that, sister, you can talk for me so that they can understand what I need to say. So I had to calm her down, and we have to come out with a story. And then later she was identified. And then she ended up being in the prison for 3 months. This was like reflection period for her, for when they're still finding a place for her to keep her. And then she was released. So you find out that the moment she was released, she tried to run away out of Denmark because it was already trauma for her. And then she was arrested.
And she ended up with one of our people from here in Austria.
Yeah.
In fact, we're sent off, I think, by, of course, the network that she worked with. So she was arrested in Austria. And then we had, this is showing how there's problems with also a proper coordination in these cases of vulnerable people. We worked with the organization, who know which one we are. I don't think we should probably mention them, but they are here today. And then she was deported back to Denmark without any of the authorities being informed. We then found out from the organization in Europe that she was being deported at the last moment, only the morning that she was being deported. And we informed the Center Against Human Trafficking, who didn't know that this woman was arriving. We had all the way along said, we're sorry, we know that this woman is going to be placed back in prison. And of course, that's what happened. And now we're going to be visiting her in prison next week in Denmark. The same one who was identified as trafficked, highly vulnerable. Go on, Mercy. Sorry.
Yeah, it's okay. So you find out that also communication, it's really hard for victims of human trafficking. So the Denmark system, it's not working, and it's not giving residence for the victims of human trafficking. Thank you.
We finished.
Thank you, Michelle. Mercy. I think it sounds like what you're describing couldn't be further from unconditional protection and assistance to trafficked people. clear violations of the non-punishment principle as well. Really, yeah, what we need to see changing. One of the things that you mentioned as well is really the links between asylum, international protection, also family migration and family and reunification policies, labor migration policies. So this also came up, Maria. You were giving the 5 different grounds in Serbia, and also including humanitarian reasons and international protection. Maria, maybe could you share a bit, do you know if victims of trafficking are able to access residence under any of those other grounds? You said it's not working really in practice for those related to trafficking, but what about asylum and humanitarian reasons? We heard in Denmark, no. What about Serbia? Thanks.
I'm off. Yes, we actually tracked this, and unfortunately, we don't cases from practice showing this, but now we are in one of the cases, we are doing a test case, actually, what would happen if the victim would be granted the status on humanitarian basis. And also in one case, we will test what will happen if the victim of trafficking will enter the asylum procedure, which now in Serbia is lasting average around 3 years. What we know that in this asylum procedure, the victim would have right to work after 9 months. So 9 months she needs to stay in an asylum center, and after that she has the right to work. So it's still early to say what will be the results in these 2 processes, but definitely it will be good to see, is it more efficient than being in the process of getting the residence as being a victim of trafficking, identified victim of trafficking.
Thank you, Maria. We also had a question from the chat explaining a similar situation in Russia, that the only way for victims of trafficking is to apply for asylum, and otherwise really not succeeding to get resident status. Are there any countries, maybe Petya or Maria from the REST project, where you saw that there are actually good examples of victims of trafficking getting protection through asylum and through the international protection system? I don't know if Petya or Maria.
And to unmute, yes. Did I manage to unmute myself?
Yes.
Yes. Yes, Grete is systematically putting the question to the countries it evaluates as regards the number of victims of trafficking who have received international protection. And unfortunately, very few countries have data on this. We are often told that the authority which handles applications for international protection does not keep data which is disaggregated on the basis of the grounds for being granted international protection. So it is not easy to have hard data, but we are often given examples of cases where this happened. I can remember that there is case law in the second instance of the French system for international protection of victims from certain countries being victims of trafficking originated from certain countries being considered as belonging to a particular social group, the social group being of human trafficking, and the risk abuse the principle, violate the principle of non-refoulement. So there is, as I said, case law in a number of countries, but difficult to have statistics. If I remember well, from the REST project, Spain came out as a country which is doing quite well when it comes to both the legal provisions for granting residence and also international protection, and also the practice. I don't think maybe we have someone from Spain in the amongst participants. It's very encouraging to see that some countries like Finland, we heard yesterday at the conference, as a result, and I saw in the chat, as a result of a study which was commissioned, carried out by the national rapporteur, and presented to Parliament. There is now a move towards changing the legislation and making it possible for victims of trafficking to be granted residence on personal grounds. So there is a positive move if you want in some countries. The situation described by Michelle and Mercy as regards Denmark, unfortunately, also according to Greta's observations, is probably one of the worst in the Council of Europe member states, if not the well, parties to the convention, if not the worst. Yeah.
Thank you, Petya. One maybe quick follow-up question to you, because I mean, I think we also need to underline that the international protection system serves certain purposes, and the residence permits on personal grounds, as you described very well at the beginning, it's really about unconditional assistance protection. It's the foundation for safety and stability and enabling access to justice, and really meant to address people's needs. I think that's how you phrased it. When Greta is looking and exchanging with different state parties around this issue, are there reasons why countries also say that they don't provide these residence permits on personal grounds? Is there, do you see consistently some kind of argumentation that we should be aware of in terms of states' reluctance to provide these essential permits?
Yes, there is a pattern, if I might call it so, and it is usually feared that victims will be abusing the system and that they're making false claims or false complaints, that they're claiming to be victims in order to remain in the country. And of course, this is not confirmed by any of the data, any of the facts. If anything, we do not see people self-identifying. On the contrary, it is quite difficult sometimes to make a person confident enough to be saying, I have been a victim of trafficking, even when it is obviously the case. So these claims and these fears that the system would be abused, they are not justified. But we are often told this by law enforcement in particular, that they fear this, and this is being used also by politicians. I feel to push also for changes in the law. There are concerns, I know, in the UK now around the new bill, nationality and borders, I think it's called bill, and what it would mean for victims of trafficking.
Thank you, Petya. Yeah, we at PICUM also hear these very circular arguments that come up again and again without really any basis in evidence regarding the way in which undocumented people or people with precarious status make choices, kind of ignoring the institutional power imbalance in which they're obviously operating. Maybe sticking with a similar kind of thinking about some of the arguments of certain states around the way in which they make choices in terms of their policies. There was a question, Michelle and Mercy, that if persons are identified as trafficked and still detained, what is the argument to not apply the non-punishment provision, and not to grant at least the temporary protection? Is there, what kind of reasoning are you seeing around these policy decisions?
Well, the thing is, this is a kind of administrative procedure that has slid its way into court proceedings. And this is fueled by the fact that the lawyers are only paid a limited amount to put forward a defense and to a reasoning. And that the court proceedings, once someone has been arrested and, for example, accused of fraud, but in the initial part of the case, the fraud was not linked to human trafficking, even when at a later date, it is brought up very clearly that this person is trafficked, the lawyers will have to spend a lot of time to find out about how the non-punishment paragraph functions. And they would actually have to probably make a precedent in law, because nobody up to now, all of the lawyers that I write to, the moment that we get an identification through, I write to the lawyer and I say, at this point, you must now, within the next 2 weeks, while there is an appeal that's possible, you must say, I wish to appeal this case on these and these grounds. And as a layman, I then write to him and say, well, there's the non-punishment paragraph, you need to do this now. Our experience is that lawyers just don't do this, and they go in another direction. And this, so very, very few of the lawyers, or in fact none, have made a precedent in law to actually try the possibility of saying this person should be looked at under the non-punishment clause. They don't bring it up in court. So this means that when it's not being brought up, nothing happens. And I think it's because they think that they're going to lose from the start. So we're still looking for a lawyer who's going to actually try to appeal. What happens as well in this case means that the person has got a 6-year ban for re-entering Europe. So that means that even in a case like the recent one, where the person was married to a Spanish citizen, they were not allowed to return to Spain because they had a 6-year ban. And by that time, the Spanish authorities then refused this person entry. Therefore, they were deported under a so-called voluntary return. Does that make sense? What you've got is a situation where the lawyers are not, we say in Danish, they don't have the right clothes on and the right information to actually dare to take up these proceedings. And the court proceedings are not normal court proceedings. These are court proceedings that are specially kind of set up within the prison, where there is a very quick proceedings, which basically ends up with, we've imprisoned this person now, we're going to continue under the Aliens Act and other acts, because we think that this person might run away, we're going to keep them in prison until we can deport them. That is the way that the court proceedings function at the moment with the people that we're working with. Of course, there are people who also do receive some assistance if they actually follow the full description of a victim of trafficking who is going to cooperate entirely and completely with the authorities in a voluntary return.
Thank you, Michelle. Really underlines also, yeah, the role of lawyers and strategic litigation, actually getting that case law on the books. I don't know, Maria, if there's also any kind of, I know Astra is very involved in really taking pioneering kind of legal cases for exploited workers. Do you see developments there in Serbia in terms of the case law? And do you think that would be a way in which to also push for the law and policy around permits to actually be implemented in practice? And maybe also, what would you maybe share as reflections in terms of what we could learn from the Serbian example for other countries?
Listening to Michelle and Mercy, I'm thinking how actually on one side you have laws, you know, and on one side actually you have politicians and state officials and institutions who are afraid that victims of trafficking will be false victims of trafficking and misuse the system. And then on the other side you have laws and procedure very, very strict, and then you don't, institutions do not obey them, and then pushing victims to really misuse this system. And I completely agree with Petya. I'm against going through the other procedures if we know there is no base for humanitarian and other residence permit, if we really have good laws that just need to be implemented, and what we can do to implement them. And yes, Astra has been working a lot on the legal support to victims, and now has been almost 10 years that we developed a network of lawyers. We have a network of 25 lawyers, specially educated and for supporting victims of trafficking. And thanks to that, we also monitor the court cases of trafficking for the last now 11 years. We analyze how our court practice has been changed. Also last year, we have 2 very successful cases. One is the case before the Constitutional Court regarding the minor victim of trafficking who were sexually exploited, where Constitutional Court confirmed actually that the system violated the rights of the child. And the other one is the case that we've been involved in supporting victims. It's famous Serbas case from 2009, which resulted with Zoletić versus Azerbaijan judgment, also case of labor exploitation. So, but also it was after so many years, but you know, the justice is slow. So definitely I would strongly support governments to follow the model of parallel systems of identification of victims from identification of criminal act, but only if they cooperate in the best interest of trafficked person and successful prosecution, you know, not to harm the victim. Second, the lessons learned we had from REST study is that it's not enough to have laws and procedures described in the laws if you don't amend bylaws and internal procedures of the competent institutions. And the last but not least, it's not enough to have the system and the laws, but you also need to have the civil servants who will know how to implement these procedures. Even in the cases of political party employment of civil servants from the top to down that we have in Serbia, and now we already pretend it's normal, it is necessary to prescribe obligatory and constant permanent education and sensibilization of the staff, but not only going to the trainings and, you know, but also discussing about concrete issues and problems, exchanges the experience, where are the gaps, why they cannot implement certain procedure in certain way, you know, try to explain that. And also when I say civil servants, I think also permanent education and check of that knowledge of the lawyers, decision makers, and other people working with such vulnerable groups like victims of trafficking in human beings.
Thank you, Maria. One of the questions in the chat was to all the speakers and kind of draws on points that you're making, that you're doing this analysis, you're monitoring the situation in terms of the human trafficking interventions, the policy and strategy. Would any of you like to elaborate on how effective you think the different frameworks that you use in terms of monitoring and the relationship between the different actors to actually get implementation of a human rights-based approach in practice? I don't know if who would like to reflect on that a bit more.
Maybe I can start.
Please, Petya.
Yes, so we have, through the work of Greta, collected information on how the state parties to the Council of Europe Convention, what the legislation is and what the practice is, and this is quite a lot of material which is publicly available. There are 48 countries which have joined the Council of Europe Convention. One of them has not yet been evaluated because Israel joined quite recently, but all the others we have reports and data. And I think what is clear from it is that when the bar is really high for granting residence to trafficked persons, and when it is very closely, tightly linked to the criminal investigation, in particular for human trafficking and not for another offense, then there is very little incentive for victims to come forward, you know, to accept assistance and to cooperate. So it is counterproductive also when it comes to the punishment of traffickers. So it is in a way reinforcing the impunity yes, I'm sorry, I was looking for the word. You know, it is not only affecting the rights of people who have been trafficked, but is also counterproductive and goes in the direction of more impunity for traffickers. This is a message which we are consistently putting across to governments in Greta's reports. And here I just want to say that, as you probably all know, the European Commission has opened a process of assessing and possibly revising the EU Anti-Trafficking Directive. There was an invitation to make submissions, and I know that many have made such submissions. I think they're publicly available, of course, on the site of the Commission. And one of the arguments which the Council of Europe, Greta's group of experts, put across is linked exactly to the provision of another EU directive from 2004 about the residence permit for third country nationals. And that directive makes the granting of such residence permit exclusively on the grounds of the victim's cooperation in the investigation criminal proceedings. So opening up the issuing of residence permits also on the personal grounds of the personal situation of the victim is something that Greta has suggested to when it comes to revising the EU legislation.
Thank you, Petya. We also see it in terms of how the lack of ability for undocumented people and people with precarious status to actually come forward, and not knowing if they are indeed, as you said, going to get recognized to meet that high threshold. It's actually one of the drivers for exploitation, as people really see that they're completely disempowered, and indeed, like without firewalls, without safe reporting, enabling people to engage with law enforcement, to engage with labor authorities, this can actually be used by employers as kind of wielded over them as a threat that they will deport them and that they have no kind of power in the situation to negotiate better conditions. So very much appreciate the work of Greta, also seeing that in terms of the more broader system of labor exploitation and the need for having both on personal grounds, but also those kinds of ways in which people can interact with the relevant authorities without facing immigration enforcement. We actually have a request for the floor from Thomas Leigard, who is from the Danish Center Against Trafficking, a government organization who'd like to also share their perspective on the situation in Denmark to complement Hope Now. So, Mr. Leigard, I give you the floor.
Thank you very much. Well, first of all, thanking the organizers for this highly relevant side event, and all the panelists for insightful interventions. We have a very close cooperation with Hope Now. I'm a social worker in my daily life, so we have hands-on cooperation in several of cases, and Hope Now is doing extraordinary work, both in the casework, but also in the advocating the rights and needs of victims of trafficking. There are a few things that I'd like to just clear up about the Danish situation. One, we have the reflection period is given for 30 days, and then there's a possibility of extending it. The residence permit is not the reflection period is not a residence permit, and there's a possibility of an additional 90 days, all in all 120 days of reflection period. The second thing is that there is a possibility of getting a residence permit for victims of trafficking in Denmark if their presence in Denmark is needed for law enforcement to continue their work. And this is a very easy, non-bureaucratic way of obtaining a residence permit. And with that also comes, a multitude of support systems. And then also, the situation of people being detained, it's normally based on different situations. One being that the person has committed an offense that is regarded as a severe offense, and then the Danish authorities, the prosecutors and the courts can make the decision that the offense weighs more heavy than the fact that the person has been trafficked, and therefore they may reduce the sentence given the fact that the person is a victim of trafficking, but they may also keep them in detention. Another reason for the authorities to keeping people in detention is based on some of the rules in the Aliens Act. So just to clear that up, thank you so much for giving me the chance to do that.
Thank you for adding these additional information. So we're starting to wrap up a little bit, getting towards the end. I'd like to give each of the speakers a chance to take the floor again and really focus in now on recommendations. Where do you see what change needs to happen, both in terms of in your countries for the national organizations and at a broader, more regional level? Maybe we can turn first to Maria.
Maybe I will repeat what I already said, but definitely I think the government should consider that fully implement the obligation and recommendation that assistance to victims of trafficking and presumed victims of trafficking has to be priority, and in that sense to prescribe all necessary laws and bylaws, internal action to support that idea. And one of the first steps is definitely providing residence permit for presumed victims of trafficking, so all other assistance could be implemented fully. Also to remind again that support should not depend from the victims' involvement in the criminal procedure, because we know, and other procedures, because we know from practice that these procedures are sometimes slow, sometimes traffickers are run away, sometimes they die, so victims should not suffer because of that. She already suffered enough. So the second thing definitely is permanent education of all the people involved, governmental, non-governmental institutions, so on, who are in contact with the trafficked persons. And the last one, but I don't have solution for that one, if we already have laws and bylaws, good ones, how to put them in practice and following strict procedures, how to make people who should implement these procedures to do their job. This is something that we in Astra still didn't discover. And just to, I need to reflect to your previous question on monitoring. Definitely, since we are an organization who is providing monitoring, who is providing assistance to victims, but also doing a monitoring of other institutions in national refer mechanism, sometimes it's really hard to explain how we can do both, especially when we need to discuss about findings which are not so positive. But I think it's important also the way how you present your findings and recommendations, because it's important to know that it's for the good of victims of trafficking and people who survive trafficking, and not fighting among each other who made a mistake and so on. So I think we should all keep this in mind, that the final result and benefit for these people is a priority.
Thank you, Maria. I'll give the word to Michelle and Mercy.
Yes, thank you. I would like to add something. I think it's also good if the government can give the victims, the government of Denmark especially, can give the victims of human trafficking residence permit. At least that is will enable them to at least to adapt or get into the society in the way, the easy way, than for them to get married or having a child. So you mean that means that even if they can give them residence permit, they can really do well. Like maybe they can find job on themselves, they can educate themselves, and then also what they should follow up is also when the victim of human trafficking has got this permission through marriage or through having a baby here, you find out that the system really forgets them, and they're not seen as the victims of human trafficking anymore. They are forgotten, and the trauma behind it is always continuous. So it's hard for them to also adapt. So you find that there's still a double problem somewhere. So I think they should work on that, on following up on victims of human trafficking, whether they've got their residence in other way or the other. Thank you.
I just make a comment about the witnessing that was mentioned by Thomas from the Center Against Human Trafficking. Witnesses receive protection while the court cases are going on. But I have certainly been told on multiple occasions that there is no possibility for full-time residency. Also, that is sort of built into the system to really protect someone. So you're protected while the case is going on, but what happens afterwards? So long-term witness protection, I think, is very much in question. Regarding the fact that people stay in prison because the actual offense weighs heavier, which has been suggested. Fraud has been one of the main parts that we've worked with that the person has committed, and the fraud has often, if not always, been directly related to the fact that the person was trafficked. So I think that this certainly is not true in many of the cases that we work with. And of course, a lot of this is correctly, as Thomas from CMM suggested, this is all fueled by and allowed by many of the rules that have come in with the so-called Aliens Act. And also the whole of this system is fueled by the 50 and more immigration laws, which have made it more and more difficult for anyone to actually gain a foothold in a dignified way in Denmark. Thank you.
Thank you both. We also had a comment in the chat from OHCHR saying for us as NGOs to consider involving writing to the UN Special Rapporteur on trafficking at if there's particular cases as well, to bring them to their attention and see if they can also communicate with the government about that particular situation. So we can also bear in mind the role of the UN Special Rapporteurs. Petya, I'd like to give you the floor for your kind of concluding recommendations and thoughts, please.
Listening to all of you, I was just struck by how interconnected the different rights and gaps are. It's a full circle, which seems to be sometimes a vicious circle when there's no identification, and then no assistance, no recovery and reflection, no residence, no non-application, the non-punishment. And it's a full circle of failings. And this happens when the system is, if I may say, disjointed. So we need to make sure that all the connections are made. I saw that some of the participants refer to the national national referral mechanism. And this is when all the relevant parts of the system are interconnected. So we need to move from a disjointed to a connected way of approaching the issue of the rights of trafficked persons. I was struck by what Maria said about civil servants not knowing how to apply the law, and this is exactly when you have these failings and this disjointed approach, where one part of the system doesn't know what the other part is doing, and like in this comedy show, computer says no, and everything fails. So this is what we need to work on, putting all the dots together and connecting all the parts of the system.
Thank you. I won't attempt to summarize everything that's been said, nor the recommendations from all our speakers, just maybe come back to, in some closing remarks, just the point that Petya, you made at the beginning, saying that a cornerstone of a human rights-based approach is that all trafficked persons, so regardless of the form of exploitation or the resident status, they're receiving protection, they're receiving assistance, and a durable solution based on their needs and rights, and not on the interests of law enforcement. And so we need to really think about how granting long-term resident status is an essential tool to provide protection and remedy, and including protection from re-victimization in the future, and find a durable solution in terms of people's rights, safety, and dignity. But at the same time, see this residence permit as part of a broader picture. We've been talking about the asylum procedure. We see that, for example, people in Dublin procedures are not being granted the reflection recovery period. How can we, as you say, make the connections and actually improve the international protection procedures to do better for identifying and providing referrals and supporting people who are trafficked or otherwise exploited? Then we also need to look at residence and work procedures and family migration procedures more broadly. We see that labor exploitation is a continuum, and trafficking is often the vulnerability that people have because of their resident status being precarious, dependent on somebody, or irregular are key drivers for exploitation. So we need to strengthen the residence and work permits that are available to people for labor and in situations where people might be facing exploitation. We had the example of Finland was also shared in the chat, where there's been some positive measures around residence permits for exploited people, but also bridging continuation permits. So people who've had a work permit that's dependent on their employer, they can actually access a continuation permit if they've experienced exploitation, to not fall into a situation of irregularity, and have space to find another job and to recover from that. There's also something, a similar permit in Ireland that's also available for people who are undocumented, who have at some point had a permit but have lost that permit through no fault of their own, particularly labor exploitation, to re-enter the labor market and look for another job. And that's one example, but of course we're also happy to have the regularization ongoing more broadly of undocumented people in Ireland, based just solely on their residence in the country. So those are some examples that I'd like to end with, to see how we see residence permits for trafficked people also within the broader framework of strengthening residence and work procedures, as well as strengthening access to justice for people, regardless of the level of exploitation, to ensure that undocumented people can engage with relevant authorities and exercise their rights without any fear or risk of deportation, as well as have possibilities to regularize their status and access a secure and stable permit in the country. So with those remarks, I'd like to thank very much all of our speakers, as well as you, for taking the time this morning to be with us and discuss this issue. Thank you for joining us. I'll close.